The order is in response to a public interest litigature filed by Rajesh Shanari against the state of Goa and nine others, including the company which secured the permission to conduct the Sunburn EDM festival in Anjana in December 2022. The PIL specifically charges the organizers of Sunburn conducted their EDM festival from December 27 to 30th by violating noise pollution rules and levels rampantly. The court observed that music beyond permissible limits was played beyond 10 p.m., with both the GSPCB and the PIF Anjana playing a blame game, shifting the blame on each other, with neither of them acting against the Sunburn organizers. Goa authorities were waiting for Sunburn to get over for the complaints of citizens against noise pollution to die down, said the High Court. It further said that the Goa government authorities take great pride in tolerating the breaching of the noise pollution rule and the court's directions. Going beyond the Sunburn Festival, fingers have been pointed at the Pollution Control Board officials. Here are some of the reactions.
The recent EDM festival that was organized in the last 3 days of the last year, after the High Court having strictly directed the government and its law enforcing agencies, the machinery, to be very strict as far as the sound is concerned and not to allow it beyond the reasonable, the permissible decibels. Yet it created a disaster for people around that area. A writ petition was filed and the court, taking it into consideration, seeing the facts, directed that at least on the 30th to see that it does not exceed the permissible limits. But to the surprise of the court, not to me, the fact is today the government, the law enforcing agencies have proved one thing, that they pay scant respect to the High Court's orders. Even the judiciary today is in such a fix. It can only pass orders, implementing orders, that is to implement the orders that is in the government and in this government machinery, just does not do anything. And the court, it has come to a point that the court may have to directly employ its own staff to take necessary action.
I have found that in the recent times, government in the process of making it easy for a lot of businesses to come and start doing their work here, have started a single window process where an application for events like the Sunburn, the Purple Fest, etc. have all been taken through a single window where all permissions are granted on payment of the requisite fees at one state. I don't know whether this has been done for the convenience of the party applying for such a license, or whether it is for the convenience of the minister concerned to make his own party out of whatever he is earning. But what seems to be surprising is that when it comes to fixing responsibility about issues like the sound restrictions, like pollution, like the regulation of traffic, all those things, at that time when the government has to answer to the court or any authority which is posing such a question, judicial or otherwise, the departments tend to blame one another and distort the issue, trying to avoid responsibility. When the government is granting such permissions under single window, then why not fix the responsibility also under a single window? The issuing authority, although the permissions are granted from separate departments, the chief secretary and the department heads who have granted permissions and not kept checks and balances on such events should be held accountable. And government has to stop filing these frivolous affidavits where they try to blame responsibility on one department or the other. If there is a particular department, a ministry, a minister, or an official, maybe the chief secretary or the secretary of the appropriate department, who have granted some such permission, it is incumbent upon them to answer these questions, and they cannot blame the some other authority for not fixing such responsibility on themselves. So I am glad that the High Court has issued these directions.
Bureau Report, Herald TV.